Joining me today is a trial lawyer focusing on civil, criminal, and constitutional law, and according to his Twitter bio, he's America's most successful political gambler. Robert Barnes, welcome to the Rubin Report.
Happy to be here.
I am glad to have you here because you, sir, are smack dab in the middle of a million things that I'm thinking about all the time. So I'm glad we're doing this before we do anything related to civil, criminal, constitutional, or any other kind of law. Political gambler. What are we talking about there? I know what we're talking about, but tell the people.
Sure, I started doing it when I was real young. So I used to bet friends and other people with elections, and then started doing it, became sort of legal loosely in 2004. So I started betting on presidential elections, and it was sort of a side hobby until the Trump election. And Trump, I thought this was a very money-making opportunity. The British betting markets are now much bigger than they ever used to be. So I could bet as much money as I possibly could, and basically dug in much deeper than I had before. So I'd sort of been around politics, but hadn't dug in deep for maybe 20 years or so. I mean, I'd been very active, but then had become inactive, had become skeptical of the political process, and decided, well, I should really dig in. And as part of this, I discovered this whole emerging movement in a cross-section of areas and what was happening ideologically, so I became involved for other political and legal reasons along the way. It was sort of like a Scott Adams win bigly kind of thing, where you get the...
It's there somewhere.
Exactly.
Yeah, oh, there you go.
Exactly, where you get like 6 degrees of separation, you're trying to learn this, you end up learning 4 or 5 other things in the process. And so I went to the Republican National Convention, the Democratic National Convention, traveled across the country, talked to tons of people, dug into what was happening in the social media space, the Reddit space, the Twitter space. I didn't know what Twitter was until then, really. I knew some bird thing.
It was a happier time.
Exactly, it was. And maybe YouTube was still YouTube, it wasn't CensorTube. So I was involved and invested in it, went over to the UK, placed a lot of big bets. They thought I was nuts when I was doing it. They're like, Trump's not going to get elected. That was the sort of consensus. So much so that one of the big books, Paddy Power, actually was paying out Hillary Clinton bets before the election.
Jesus.
So if you had bet on Hillary Clinton with Paddy Power, they acted like you had already won and paid you out.
Are they still in business?
They are still in business, though they took a huge hit on the election after they'd taken a big hit on Brexit, which I'd bet on before that. And then after that, had bet on various European elections. So it was just understanding how the electorate works. I'm a sports bettor as well. And being able to predict and forecast elections was fun, and it was a way to just make extra money. And in the process, ended up having this whole life experience that was fun and entertaining and very profitable.
Can I ask you what kind of profits we're talking about here?
About $500,000.
Not bad.
Yeah, it was very nice. If I could have bet more, I would have bet more.
Yeah.
There was only limits. As an American, you only have access to the individual betting shops. You can't get onto the Betfair and the BetTrade markets. If I could have made 7 figures with ease. It would have been nice.
Jeez. All right. Well, there's a lot to talk about there, but I really want to focus on some of the legal stuff because we chatted a little bit in the green room. I'm starting to think, as much I obviously am a free speech guy, and we're going to talk all about the First Amendment and all sorts of things, that the way the world is going right now with the platforms and with the trolls and with the anonymous accounts and with the targeted harassment and with the way that we see media members attacking kids, which you're very intimately involved with, and a whole bunch of other stuff, I'm starting to think we really need some legal answers to some of these problems, which is really against my default position as a person in terms of speech, and that's exactly why I wanted to have you here. So before we get to all that, just tell me a little bit about your legal history. When did you even get interested in law, and what sort of made you say, all right, I'm going to be a lawyer. Lawyers aren't that well liked. I'm going to be one.
Exactly. Well, I've always liked underdog representation, and that's sort of what my legal practice is, and that goes back to when I was a kid. My favorite TV show was The Equalizer. So it was always to equalize the odds and to represent people against, even if I'm representing someone that's famous or well known, they're stacked up against someone that has more institutional power or wealth or the U.S. government behind it. And so as a kid, I liked shows like Matlock and Perry Mason, and that was part of it. And you'd see lawyers as being integral to the process of making meaningful change, and particularly to stand up for people who couldn't stand up for themselves, and use our legal system and legal rights to accomplish and achieve those objectives. And so that's why the law always appealed to me. It didn't appeal to me from a money-making perspective, though I've been very, had been lucky in that regard. It appealed to me, and didn't appeal to me on a status basis. It appealed to me as I can make a difference for little people like my father, who spoke out his whole life, and often was punished for it. And there's the old biblical proverb that says the sins of the father will be visited on the son. I always say, well, the sins against the father are long remembered by the son. And so he was mistreated and maltreated because he stood up, not for himself, but for other people in a wide range of environments. And I just wanted to equalize the playing field if I could. And
was he a lawyer also?
No, he wasn't. He was an accountant, but it wasn't a certified public accountant. He went through all the craziness that. It was my first experience with the credentialing society. Here my father was a very skilled and gifted accountant, but because he wasn't a certified public accountant, he'd grown up in an era where that wasn't necessary, he couldn't get the kind of jobs that other people could do. And so he was often both overqualified and underqualified for employment. And then he had a habit of standing up for people who were being maltreated or mistreated in his work environment or other environment, which led to him, he ended up being a newspaper guy, delivery guy. So when I was a little kid, he was delivering newspapers, throwing them outside the door. We did a morning route and an afternoon route. And then he ended up doing inventory work. So he just picked up whatever blue collar work he could. So even though his education and his intellectual capabilities far exceeded what he could get economically, it was the product or side effect of the credentialing society and the ability of more powerful people to take advantage and misuse and abuse that power against less powerful people like himself.
Wow. So, all right, so let's flash forward a little bit to what were maybe one or two of the cases that kind of got you sort of on the map so that now you've become one of the sort of, I think, one of the central legal figures in the free speech battle. So
I started out doing all kinds of free speech representation, represented victims of domestic violence, was suing big banks before anybody was suing big banks in subprime lending. I'd clerked for a Native American tribe, I'd clerked for a big corporate law firm, I'd clerked for a street lawyer. I always say if anybody wants to learn legal education, just read all of John Grisham's books. You'll get a good sense of how the legal practice really works. And worked for a big high-profile plaintiff's lawyer, and finally got to a space where I could do the kind of cases I wanted to do. And I liked First Amendment cases, and it happened to parallel in two areas of law. One was civil, where I was representing Ralph Nader. He went on TV and said, look, I'm getting bombarded. I have no lawyers left to help me. If somebody can, please reach out. I was like, sure, I'll take the case. So I remember we did the case in Arizona. It was me, Ralph Nader, and like 12 lawyers kept coming in. I kept wondering when the door was going to shut. Another lawyer came in. You had the Democratic Party, Republican Party, both aligned to prevent his access to the ballot, deny people the right to circulate petitions for the cause or candidate of their choice. And so I took that case, and it took 4 years, a lot of litigation, a lot of fighting, but ultimately we got one of the most important precedents in the country out of the Ninth Circuit Court of Appeals. It's now one of the most cited cases in the country that protects the right to circulate petitions, the right to speech in the context of elections, the right to choose who you want on the ballot, the right of third parties and independent candidates to access the ballot.
In a weird way, though, even though just by the fact that it took 4 years, isn't that part of the problem right there? Because 4 years later, it's like he doesn't necessarily have the energy to run again, or the movement kind of moves on to something else, et cetera.
It was like the beginning of lawfare of its own kind. Politically motivated, ideological lawfare to exclude independent and dissident voices from being able to meaningfully participate in the political process. And the main goal and objective is to silence the audience, to not allow the audience to hear or choose or participate in the way they want to choose. They don't get to choose their news. They don't get to choose their views. That's what the censorship campaigns were about. And that crossed over into representing people who were accused of being tax protesters. And these were people who had very distinct political views about the way the tax laws were operating. They were mostly upfront about it with the IRS. I mean, how many people, write letters saying, I'm not going to pay taxes and here's why? Right. I mean,
So mostly these were libertarians, basically, right? It's never somebody that hates the tax system because they want to be taxed more, right?
Exactly.
That's never happened.
Precisely, exactly. Yeah. And it's people being open and honest about it. They're not trying to cheat anybody. They're not trying to defraud anybody. And the U.S. Supreme Court had said 20 years ago in a case called Cheek versus the United States, they were not supposed to put people in prison for having different beliefs about the tax laws, especially given this is a country that was founded on people who had very unique beliefs about the tax laws. So I ended up representing Wesley Snipes in that context. I'd also represented him previously when he'd been falsely accused of parenting a child in New York, where they were abusing the family court system to invade his privacy, to lie and libel him, and basically because of his celebrity, use his celebrity to make themselves notorious. So we brought a unique civil rights case in that context, had won, got them to fold and capitulate. He hired me then to represent him in the criminal case on a whole bunch of tax charges, ended up acquitted of all the felony, fraud, conspiracy charges, and even half the misdemeanor charges.
On cases like that, I'm always curious, when it's a high-profile, rich celebrity and it's tax-related, I always think it's like these people, a guy like Wesley Snipes, movie star, he's worth millions and millions of dollars. The idea that he would, and I don't know the specifics, so please correct me if I'm wrong, but the idea that he would know every specific thing that his accountant was doing all the time, seems crazy to me. Like, he's running a business where he's mostly probably focused on acting and traveling and everything else. And it's like the idea that unless he instructed the guy to do something illegal, that you'd end up in jail because of something like that seems pretty bananas to me.
Completely, because what happened with him is he'd had one accountant advisor that he started to distrust. He thought, I think this guy's up to something on real estate deals and other deals. It turned out he was completely right. He was trying to tell the New York authorities for years before the guy ended up getting busted. And this guy was involved with Tom Brokaw. He was representing a whole roster of high-profile celebrities. Turned out he was embezzling from them en masse. He'd abandoned his wife for a stripper. Long story. So this guy ended up going to jail for a long time. But Snipes was like, hey, there's a problem here, and nobody would listen, and that led him to turn to other professionals. And they said, you know what, if you have any questions, we'll go right to the government and get your answers. He was like, well, that's got to be no problem. They're going to talk to the government. They'll figure out what it is.
No way. That's how this unfolded?
That's how this whole thing unfolded. It was, in fact, they even tried to delete and destroy all of his letters and correspondence and communications. And luckily, he had separately backed them up. If he hadn't, we wouldn't have been able to prove how much he had communicated directly to them. He even asked to be audited. He said, come in and audit me, and then come back and tell me what is it I owe and why it is I owe it, and how does the legal system work. And this is someone rooted in the African American and Native American tradition who has a long history of the laws not being applied the way they're supposed to be on the books. So the idea that maybe the law is not being applied the way it's supposed to be wasn't foreign to him. You have Native American tribes whose tribal agreements are still not being enforced. You have African Americans between 1865 and 1955 in the United States, like his parents, like his grandparents, who said the law in the book said they had the right to participate in the political process, the right to be on the jury, the right to run for office, and yet that wasn't happening in reality. So the idea that there was some mismatch here made sense to him, and he said, well, let's go right to the government. And I'm Wesley Snipes, I have a little bit of attention, they'll probably answer my questions at least, and then everything will get resolved. That's why the jury was shocked by the case. This was a very conservative jury. The lead jury foreman was a guy who had been a long-time corrections officer in upstate New York. They had deliberately manipulated the jury pool. It was literally an all-white jury pool. So there was a joke that it was the only thing more white than the snowfall from the Green Bay Packer New York Giants game the day before was the jury pool in the Snipes case. But 9 of the 12 jurors who were honest and got onto the jury said they didn't think he should be convicted of anything. There were 3 jurors who were holdouts who said we want to convict him of things, and they admitted they came in with a bias before they became part of the jury. So on the misdemeanors, they did a split verdict. They said, well, we'll convict him on these 3 misdemeanors, even though we don't think he's guilty of them, because that will be no problem. They didn't know there'd be a wacky sentence because there was shock at the outcome of the case.
So how much of law is just that? Just the public attention stuff, manipulating the media? I don't have to name, I could probably name a zillion lawyers that seem like they're far more interested in fame for themselves than doing the right thing. And just managing optics rather than getting to just what is right.
Precisely. That's what it often is. I mean, you're seeing it now in the Roger Stone case, where there's an obsession with silencing him. And all the people on the media on the left that talk about free speech and talk about the ability to protect yourself and how our criminal justice system has problems are suddenly mute. When here it is, you have a judge spending all this time saying maybe we shouldn't allow him to publish a book. How has that become part of American criminal justice process? So effectively, it often is defending a person in the court of public opinion, because often what the government is doing is using people as sin goats, using people as sacrificial lambs, using people to coerce public opinion, often not really rooted in the facts of a case, not really rooted in the law of a case, targeting people solely because of their celebrity or their fame. And then you have lawyers who often look at a case and they don't look at the case about how do I win the case. They look at how do I get the most press coverage, how do I get the most media coverage, and they often disserve their clients in that context. So it's critically important, especially in high-profile cases, to put the client first and to manage the court of public opinion at the same time.
Yeah, and that cannot be easy, especially in a day of social media. And look, the fact you're here talking, so it's not like you're not like a totally private person. No. And yet you want to do what's right by your clients. And
exactly. So like in Snipes' case, I think the odds, going back to odds, there was the odds that he was convicted of the top felony fraud counts was 8-1. So they said there was only about a 10-11% chance of him being acquitted. You had people on CNN saying that he had no chance to win. Some are still prominent legal commentators now.
How do we always have legal commentary people on CNN often, but all the cable networks, who get everything wrong and they keep bringing them back.
It's like their political commentary.
Yeah, what?
Oh, precisely. And these are people that have mostly never practiced law, never tried a case, never dealt with a real case. And it's amazing. They're there, they have a law degree, but they often don't have any legal experience, and they're really there for political purposes. They know if they say the right thing that their media bosses want them to say, they'll get rewarded, even if what they're saying is complete and utter nonsense.
Yeah, so one of the things that I've been saying over the last couple of years, and you know I'm a free speech guy, is that right now I'm more concerned that we're silencing ourselves than the government is coming for our speech at this very moment. Now, of course, I understand the government can always come for our speech, and there are many ways that you're laying out right there that they can, through going through the IRS or whatever else. But I'm more concerned right now about sort of the mob mentality, the way we're weaponizing the media and social media and the rest of it. So let's just start with the big question right now. Social media, are these publishers or platforms right now? Twitter, Facebook, YouTube. And can you explain the difference between the two?
Absolutely. So all of these big tech platforms originally were able to obtain their monopoly status two ways. First, they got Congress to pass special immunity laws, loosely called Section 230, the particular section of the laws that applies, that says we're going to presume that everything you do is as a platform and not as a publisher. And consequently, you'll be immune from any lawsuit as a publisher as long as you are acting as a platform.
So meaning that you're just the space, so to speak. People can put all kinds of crap up on there. You can decide what you take down or leave up, but you're not endorsing it.
Exactly. You're just the public venue. You're the venue where they're coming to organize the Republican Party on the election night, right? You're the restaurant. You're the convention center. That's all you are. And then that was even additionally privately promised by people like Jack at Twitter, who said, "I'll be the free speech wing of the free speech party." So he induces people to participate, induces people to become part of Twitter and to give them a competitive economic edge against their then competitors on the grounds that, hey, look, one, the law only applies if we're a platform, not a publisher. Secondly, we are promising you we will protect your free speech rights and your free speech liberties. Now, it's important in that context. Free speech means the right to not be stalked for your speech, the right not to be harassed for your speech, the right not to be censored for your speech. It's both. That's why I always tell for free speech is not just the right of expression. It means I have a right that someone can't target me because of my expression and use illicit mechanisms. They can question my ideas. They can attack my ideas. If I'm a public figure, they have limited space in which they can talk about me as a person. But what they can't do is invade my privacy. What they can't do is follow me down the street. What they can't do is put a billboard outside my home. These are things they can't do.
So is that to me, that's a really fascinating change on the way things have happened, because if I was to look at just generally what's going on Twitter these days, if I was to walk down the street right now and somebody just every day was waiting outside my house and started screaming at me and all sorts of things, there's legal recourse I could take, right? I can file what can I do?
Yeah, you can file a civil suit and get an order of protection against them. Like people, like I did a lot of work back in the day when I was a young lawyer for victims of domestic violence. And we were part of the beginning of the orders of protection that got instituted for them. But it's not limited to the domestic violence context. It's anybody who's stalking, anybody who's harassing, anybody who's invading your privacy. You have an equitable right and a legal right to bring legal action against them and have the court say, I'm going to stop you from doing this. And if you violate this, you're going to be responsible for legal fees. You're going to be responsible for costs. I can even put a statutory amount on there. And they often do. They'll say, every time you violate this, it's $1,000 or it's $5,000, $10,000, whatever's necessary to deter. Those laws exist already there.
So are there any laws related to that exist in the digital space? Now, again, I want to be very clean when we're doing this because, so for example, all day long, trolls are jumping at me, go fuck yourself, just the word, it's far worse than that usually, but just the worst kind of things all day long, same accounts, I block them, I mute them, they just make new accounts over and over and over. Okay, it's not the worst thing in the world, I'm still here, I'm alive, it's okay.
Right.
But doing it in the digital realm, I think people would see that very differently than stalking someone just outside of their house or in the realm of reality.
It is only to a certain degree. The same laws apply. So it doesn't matter whether it's the digital world or the physical world, the same stalking laws apply, the same harassing laws apply. So somebody who stalks can be sued, somebody who stalks, they can even be charged with crimes under particular cases. So they can be referred for criminal prosecution. That's happened to people that have done that to Mike Cernovich, for example. So you can use civil remedies, you can request criminal remedies with criminal referrals, you can bring equitable actions, you can bring legal actions, and the courts are actually very sensitive to it, particularly like in California, where because of the problem of stalkerazzi, they expanded the kind of protection either in the digital space or the personal space. And the U.S. Supreme Court has increasingly recognized that these days those spaces are indistinguishable.
So it's interesting to me because as part of, let's say, the free speech crew online right now, I'm very hesitant of a lot of this stuff because it's like, I want everyone to be able to express themselves. And yet I understand we need certain super specific laws, libel laws, slander laws, harassment laws. And yet there's a certain irony where it's like the free speech crew are the ones that are going to have to defend those laws. It's like a really weird place for people like us to be in, I think.
I agree. The way I think of it is I see it as an unequal equation. So what's happening is you're seeing big media, big powerful forces, people with big platforms be able to defame little people at will, be able to run smear campaigns against people at will, be able to attack and encourage stalking and harassment and online mobs at will, and not be held responsible. And it's the little guy that's still fighting for their free speech, and yet they're the ones, the little guy who's getting sued by big institutional actors or backed by big institutional players, and they're being sued for defamation. They're being sued for libel. They're being deplatformed. And so what we need to do is equalize that playing field, because the First Amendment is also about protecting everybody's speech, and that means the little guy can't get harassed in ways the big guy is immune from, and the big guy can't use powers that the little guy doesn't have access to. So it needs to be equalized out. So true free speech means people who are important in the independent press and the freedom of press of the independent press not be harassed, not the legal system not be used against them disproportionately and indiscriminately, not have the deplatforming happening against them disproportionately and indiscriminately. And that's what's taking place, and that's what needs to equalize. So true free speech means we need to have some equality of treatment between everybody.
Okay, so now backing that to the platform versus publisher part of this, so they help get these laws. What statute did you say?
It's Section 230.
Section 230, okay. So they help get these laws passed. Now they're treated as platforms, but it seems that they're acting often more as publishers, right?
In fact, they now admit that. So in other suits that I brought against Twitter, they said that they are a publisher and they want all of the protections as a publisher. They want all the legal privileges of a publisher. Because a publisher has a wide range of special protections, particularly if it has any institutional form or backing. So there are certain libel laws that apply to individuals differently than they apply to corporations. The same is true of big media publishers. So they're now saying to courts, so in the Prager suit against YouTube, YouTube and Google's defense is we're acting as a censor, we're acting as an editor, we're acting as a publisher, and look at all these privileges we have as a publisher. Which a lot of people, and it was one of the issues we raised, was if they're acting as a publisher, they shouldn't have the immunities of a platform. Unfortunately, the courts have interpreted what Congress sent to them in a political way. And this is often the case with a lot of law. A lot of law is interpreted through a political framework. And how they interpret it as, as Congress doesn't want us to allow big tech to be sued. So we're going to give them all the protections as a publisher and all the Section 230 immunities as a platform. So they have a degree of protection, as Senator Hawley described it, a degree of immunity and benefits that no publisher in the world has, that Congress is the one that actually gave it to them as the courts have construed it, though some would argue that's beyond what Congress intended.
Right, so Prager lost the initial lawsuit, correct?
Yep,
and are and I know Dennis, but I actually don't know the answer to this. Are they pursuing other legal measures that
They're
you know
still
of?
trying to go through the appellate process, but they're unlikely to prevail under the current environment, because the current environment is such that, like when I sued Twitter, I brought unique novel theories. I brought breach of contract theories, Consumer Protection Act theories, because my equitable theories, because my view was Twitter had lied to people to induce their participation, profited from that participation, sold that person's, someone like Charles Johnson would come in and 30,000 other people join Twitter to follow Charles Johnson. They now have all of their private information. They get to aggregate that information and then marketize it and monetize it. And then they get to censor and ban Charles Johnson forever from Twitter because they don't like one tweet he made. Well, if my view is that's really a breach of contract, that's really a breach of equitable duties and obligations. But the court saw, Congress is saying Section 230 means I'm not supposed to allow Twitter to ever be sued for anything. That's what's happened. And that's why Congress needs to fix that side of the equation, because unfortunately the courts haven't stepped up to do it themselves.
Do you think there's an interesting piece of this that is just because of anonymous accounts, and I don't know what the legal protections or non-protections would be around that, but if you generally look at what's happening online, if we removed anonymous accounts, and by the way, as a free speech guy, I'm not for that because I understand many times, I mean, I see this with people that I meet at live events, they'll come up to me after and they say, I have an anonymous account because I'm a conservative, and I don't, so it's not that they're trolls, it's not that they're flaming people or whatever else it is, but there's a piece of me that thinks, man, if you just removed anonymous accounts and put aside the decent human part of it for a second, that actually 80 to 90% of all of this nonsense would disappear because you've got brave keyboard warriors with no skin in the game that are trying to sow havoc. I don't know if there's a legal piece of this somewhere?
There's a legal way to do it. So if you're operating on an anonymous account and you're doing something that's not protected by the First Amendment, like stalking, like harassing, like invading someone's privacy, which is a broad tort that covers a wide range of remedies, including, like in the Covington case, we'll bring the first case that establishes that doxing is, in fact, an invasion of privacy. So you can sue, you can require that Twitter or Google, whoever did it, Facebook, identify that individual, and consequently that individual can be held legally liable for their course of conduct. So people who think they can do bad things behind anonymity are wrong. They can do good things behind anonymity, and the First Amendment encompasses that. Anonymity is often critical to all kinds of free speech. But if what you're doing has always been outside the scope of the First Amendment, like stalking, like harassing, like intending to censor and shame people based on lies and libels, you can be held individually liable, and your anonymity of your account will not protect you from legal responsibility.
It's so interesting because I'm hearing you on all of this, and then there is this other, there's the absolutist part of me on speech, that even though I know we need these protections more than ever, there's just this little piece of me that's like, I don't want everything to get caught up in legalese. And I guess that ultimately is the balance that guys like you have to deal with every day.
Absolutely. It was the pitch that we had made to Senator Hawley was, don't treat these as utilities and start to regulate them. I understand why people are calling for that, because what they're seeing is monopoly power. The interesting thing is, in the First Amendment, including in California, it used to be the law, and it still is the law in some places, which is if you have the effect of a corporate monopoly on the public square, you are then considered a state actor for First Amendment purposes. This was established way back because you had company towns who were like, well, how do we suppress this union movement? Well, why don't we just own the whole town? We own the sheriff, we own the cop, we own the public square. Now we'll ban petitioning. Now we'll ban circulating. Now we'll ban organizing.
So by that definition, you would argue the social media companies are?
Absolutely.
Okay.
It's called the Pruneyard Doctrine here in the state of California, which applies to private malls. Private malls can't ban you from circulating certain things in the public spaces of those private malls. Well, is there any more monopolized public square than big tech media, than Twitter, than Facebook, than YouTube, than Google? They own 85 to 95% of the public square. And all corporations are creations of the state. And they get certain protections for that because they have a corporate charter. They're given certain immunities from individual liability for participating in that company. Well, in exchange for that, once they get to the place where they monopolize the public square, those two things exist, both the monopoly and the public square, which is usually over 75, 80% control of the market space. When they have that, and when it's the public square, I think they should be held to the same First Amendment standards as everyone else, because otherwise we create this huge loophole in the First Amendment to privatize control of the public square.
So Eric Weinstein, who I'm guessing you're familiar with, I've had a couple of discussions with him about this, and one of the ideas that he's put forward, and my libertarian side doesn't really like this, but I see some value in it, is that because we don't have public spaces online.
Correct.
So it makes everything, so in effect everything's private, there's nothing public, so the government has nothing to do with anything, but maybe this would be an actual good use of the government if there were platforms that were government platforms that the only rule basically was you can't break the laws of the United States, so that people could get their information out there, but if you break the laws of the United States, you're in trouble. Then the private companies could do whatever the hell they wanted, and we'd have no reason to, we'd have no ability to stop them. But in effect, because everything is private, there's nothing public anymore.
Exactly. And so my view is that once you become a monopoly, and particularly when you become a monopoly based on federal congressional immunity, then you have different obligations than any other private actor. So that's one argument. So one argument is if you choose to have a monopoly in the public square space, you're going to have the same First Amendment rules as any government actor. That's one option. Another option is just to condition their continued immunity on First Amendment inclusion. This was the argument that I made to the Twitter lawyers in the Johnson case. It was like, look, you guys don't have to reinvent the wheel. Like, well, they said they were worried about stalking and harassing. And it's like very simple. Just take all the First Amendment rules that already exist, incorporate them within your terms of service, and then you'll eliminate 90% of your concerns and questions.
And you won't have to deal with a lot of the nonsense, right?
Absolutely.
Yeah.
Like right now, their rules would be considered void for vagueness if they were state rules, because you have rules that are subject to individual whim and discretion.
And they're intentionally written that way, right?
Absolutely.
I mean, did you catch any of Tim Pool and on Joe Rogan with Jack?
Exactly.
Yeah.
I mean, he detailed this instance after instance after instance. I mean, the way they decided to deplatform Alex Jones was highly subjective, very interpretive, and I've seen far worse conduct. I mean, for example, the Covington case, you had a prominent Hollywood figure show an image of saying the Covington kid should have to go through a shredder and be killed. You had Reza Aslan calling for him to be punched in the face.
Yeah.
Nothing was done about that. And yet, Alex Jones posts something that's just a funny video, and they're like, oh my goodness, we have to get rid of Alex Jones.
Okay, so I want to spend a whole bunch of time on Covington, because I think actually that was the moment that this shifted, and maybe at a legal sense it crystallized in my mind a little bit more. That's actually when I reached out to you.
Sure,
because I saw you just going for it, and I thought, okay, this is a conversation we have to have. But let's talk about Jones for a minute. So Jones, so you've done some defense work with Jones.
Yes, I'm representing Alex Jones in InfoWars, and now his outside general counsel on all these legal matters.
So you represent him across the board on all of these things. So I guess my first question is, what's it like when Alex Jones knocks on your door or calls you up?
He's a very animated guy, very nice guy, very open, very sincere. What was fascinating is from the get-go, he was saying 90% of what they're saying about me isn't the case. He's like, I would defend this on free speech and free press grounds anyway, but what they're actually saying, I said I didn't say. I never attacked these families. I never went after these families. I never told people to go to their families' homes. None of that.
Yeah. So that stuff specifically is about the Sandy Hook.
Exactly,
stuff,
the Sandy Hook case. And so that they took a Media Matters video and assumed that's what I said, and it wasn't really. And they took most of that out of context and didn't put in that I had corrected the record a long time ago. And so part of it was, very nice guy, actually very friendly guy, very accessible guy. Even more so than Snipes, he gets mobbed when he goes out in public with people wanting selfies and that sort of thing. And he doesn't act like the Jaguar did with the lady. He's very nice and sociable and friendly. Right. So he runs a nice small business enterprise, access TV to talk radio to internet. And he's intended to be the poster boy of their deplatforming campaigns. What I told the press is this case really isn't about Alex Jones. It's about the ability of the independent press to operate. Will lawfare be discriminately or disparately used against ordinary individuals in the same way that deplatforming is happening already in the big tech space? And so are we going to protect the little guy or not? And Alex Jones, they figured, would be the convenient. They would sort of create a parody of him, a caricature of him, that they could get the public to believe, make the audience feel bad if they watch him, may feel guilty to be associated or attached with him. I mean, as soon as my representation was announced, and another lawyer, Norm Pattis, big old school civil rights lawyer in Connecticut. I think he still has a ponytail. I mean, he's old school. Yeah. He had friends and family members that are connected to what happened at Sandy Hook. So he immediately wanted to be involved in the case. As soon as he was, Huffington Post writes a hit piece on him. They don't talk about a civil rights legacy. They don't talk about any of that. The whole thing is intended to smear him and to send a message that if you're a lawyer and you dare defend Alex Jones, we're going to try to destroy your reputation in the public space. And that's exactly the problem that needs to be fixed and remedied.
Yeah. So related to Jones specifically, I mean, one of the things that I thought was most incredible, I forget the exact order of it, but basically within 48 hours, all the platforms took him down.
Yes.
And it's like, okay, is that you guys truly are calling each other and coordinating it, or is it that you're all sort of cowards, somebody breaks the ice and now you're just followers? And I don't know that it matters either way, right? It probably doesn't matter either way. But what I thought was, okay, it doesn't even matter what he has said, short of breaking an American law, in my opinion. The real issue here is that if he can't be on there, then why is Farrakhan on there? I'm not making a direct comparison to them. Why is Hamas on there? We could do a zillion other things, you know.
The disparity is obvious and evident. There are people who've said far worse things that just happen to have a different ideological, intellectual perspective. Even if you took all the accusations against them at face value, and 90% of them are not true, and that's your typical smear campaign. The conservative or the person on the right or the person on the independent anti-war left will often be attacked and smeared. 90% of what's said about them is not true. But even if it was true, what the other side has said is usually far worse and far more egregious and far more excessive. And it's the obvious disparate treatment. They're using their concentrated power to, and including their lawfare power, to effectively wipe out the little guys so that only the big guy's voice is heard. And ultimately it's about the audience. Because Alex Jones is still going to talk. It's just, can the audience hear him? So it's about their right to choose. Their right to choose what news they want to look at, what views they want to have, how they filter information. I always say, like I don't represent people that are accused of racism or the rest. People that are actual racists, not everybody. These days, everybody's
right. Well, being accused and being an actual racist are very different
things. But
things.
people who are really involved in something, I generally avoid representation of them because I just don't want to be affiliated, just because that is an old personal issue. But if you look at what those people, I've always said, let those people debate. Because if you watch Richard Spencer debate somebody else, 99% of the time, the nice, calm, reasonable person is not going to say Richard Spencer is right. So always expose ideas to more ideas, more sunshine. Because let the ideas trust the audience. That's really what they're all saying. All what big tech is doing, what these big lawsuits are doing against little guys is intended to say, we don't trust the audience to make up their own mind. We don't trust the audience to make up their own decisions. We have to control what you think. We have to control what you do because you might choose something that we don't want you to do if you actually have freedom of choice, freedom of thought, freedom of expression.